Hello, everyone. Welcome to training. Welcome to training. Let's dive right in because we have a lot to talk about. We are going to talk about commercial unimproved property. Okay, so there is a completely different format to this. There's a completely different everything except the MLS. It's really similar, but the document itself and how the terms are described, totally different. So walk with me. We're going to use our zip forms. So let me share my screen. We're going to talk about the contract first. So from zip forms, the easiest way for you to do this is just go to your forms at the top. And from here, it's going to ask you to add a form. No problem. So you type in, you just push the add form, and then you're just going to type in commercial. And then right here, you just scroll down and it says unimproved property. Okay. So you're going to add that document, close this, and then here you go. The first thing I want you to notice is that this is a Texas Realtors document. This is not a promulgated form through TREC. TREC does not promulgate or do anything with commercial property, period. Okay, so it is not going to be the same document. It's not even close to the same format. This is a 15-page document with a ton of information in it. Okay, so we're just going to go through this in general. So paragraph 1, we're talking about the we're talking about the parties to the transaction. First thing, if you notice, it is asking for the buyer and seller's current addresses, phone numbers, emails, fax, and their names. It's not just buyer name, seller name, and then we keep moving. We want to know everything about them because this is a commercial deal. So we need to know who, if it got down to lawsuits and things like that, because obviously commercial is pretty heavy. We need to know who these people are and where to contact them. So I always make sure that I'm using their driver's licenses when they ask, okay, it's time to put in this offer. Okay, no problem. Let me see your license so that I can make sure that I put the correct information here. Okay. When you're working with a commercial deal, you can also use that line when you're signing the buyer rep agreement or the listing agreement, due to the fact that when they do go under contract, they will have to give this information over anyway. It cannot be a business address and must be their personal. Okay. Now, the property, if you, again, something else that just looks different, you have the property that's situated in this county at this address, and this entire section right here is for the legal description. Commercial properties typically have like crazy long descriptions, which is why they give you so much information, so much space to put that information here, versus with the residential contracts, it's a small line. And if it doesn't fit, as we know, we just put see paragraph 11 special provisions and we put that legal description there. With a commercial contract, they give you enough space to make sure we put everything, because it could be a shopping strip. It could be like a land for shopping strip that you're going to individually plat. It could be the parking lot. It could be quite a bit of different things. So you want to make sure that you got it all together. Now, when we're talking about the sales price is important. So in your residential contracts, it would be A plus B equals C. For here, it's 1 plus 2 equals 3. Okay, 1 plus 2 equals 3. So that would be your cash portion, the sum of all financing described in paragraph 4, which is going to be below, and then this price. So if we did 10,000 as our down payment, 90,000 as our loan amount, it would be 100,000. 1 plus 2 equals 3. Now, what it's saying here, though, is we need to know, based on how we're describing the financing in paragraph 4, will be based on what this loan amount is. Okay, so, or the sum of all financing. So let's look down here in paragraph 4, and then we'll go back up. Paragraph 4 is talking about third-party assumptions or seller financing. So it could be a mix of both, because you could take a second lien out, things like that. So we could do seller financing for some piece of it, and then we could do third-party financing on another piece of it. It just depends. Now, this gives you some of the third-party financing addendum information right here in this contract, which is why this contract is so long. In the residential contract, a house being contingent on third-party financing or not is all discussed in the third-party addendum. Whereas here, they want to discuss it right here in the contract. So because they're forcing so much information into one document, that's why it's so long. So are we going to be contingent upon obtaining third-party financing or not? We would mark that here, and then we would do this, or it could be here. You see how they didn't disappear. When it has to be an either or situation in your contract, it'll, if I mark here, it'll disappear here. And if I mark here, it'll disappear there. You know, it allows you to do all of them because you can do a mix of these because it's commercial. Okay. So now let's go back up here. When you are talking about the sales price, sometimes there has to be an adjustment. Okay. Um, So with the adjustments to the sales price, basically what this is saying is with unimproved property or with land in general, if you've ever driven by a property that was selling land, you would see something that said like plus or minus 5 acres, plus or minus 100 acres. That plus or minus is what we're talking about here for the adjustment. Because if the property itself is plus or minus 5 acres, but we find out after the survey that it's really not 5 acres, it's 4.8. Then do we want the price to be adjusted? Because typically people are paying a certain price per acre. So in this example, if it's plus or minus 5 acres, and we're using 5 acres, let's say $1,000 per acre. So if it's plus or minus an acre, plus or minus 5 acres at $1,000 a piece, my contract initially says $5,000. But I would want that price adjusted. I would want it adjusted because if it's 4.8, then now I'm saving $200. I'm now going to only owe $4,800, not $5,000. So, or in other on the other side though, if it turns out that it's 5.2 acres, that would be $5,200 versus $5,000. So you have to be ready for it to go either way. But basically, when you do that plus or minus, it's the seller saying, I know that it's like roughly 5 acres. I don't really know exactly how many acres, but I'm pretty positive that it's about 5. So let's do the survey to see. Now from here, if we do want there to be an adjustment, how do we want it calculated? Are we going to calculate it by the acre, or are we going to calculate it by the square foot? And then if we are going to calculate it by the acre or square foot, what does total area and net area mean? Okay, so let's just say we want to do it by the acre. Okay, so if it ends up being $100 per acre, I'm sorry, $1,000 per acre, and there's only 5 acres. Do we want that to be of the total area or the net area? Well, what does total area mean and what does net area mean? Okay, down here, total area means all land area within the perimeter boundaries of the property. Net area means total area less any area of the property within public roadways, right-of-way easements, and things like that. If you're buying a property that's like farmland or something like that and it's kind of off the highway, then the public roadways and right-of-way easements, that's probably not concerning you. But if you're buying in like a warehouse area and you're trying to build like a car lot or something like that, there's a highway coming right in front of you. There's a roadway to get through this land to get to the next piece. So if there's any public roadways and stuff, there's an easement there for water lines, things like that. So you might want to do it based on the net area. So let's just say that's what we're doing. So net area, and what we think net means is all of this stuff. And then we write, other information here. Okay. These are things that you have to consider on your client's behalf when you're discussing property and, the sales price. Now, down here, if the sales price is adjusted by more than, let's say, 10% of the stated sales price, either party can terminate within, let's just say, 5 days. 5 days after terminating within 5 days after the terminating parties receive the survey. Okay, so this is all talking about the price. Again, let's just say we're doing 10,000. I'm sorry, we're doing $1,000 down and it's a $4,000 loan. We're buying it for $5,000. We want to be adjustable. We're going to do the net area. We're going to talk about the net area. We want to do $1,000 because of all of these reasons. That's what net area means. And if it comes back, there's an adjustment by more than 10%. Either party has 5 days, within 5 days, to terminate after receiving that survey. Either party. Okay. Now, when you're going when you're coming down into the financing, how are we financing this? Is it a mix of all of these things? Is it one thing? Like, how are we going to finance? And it also gives you in the parentheses the different other addendum that you can add or addenda that you can add to this, depending on what options that you choose. Okay. And then now earnest money. Now, earnest money looks a lot like residential stuff. You do have no later than 3 days of the effective date of the contract, very similar, exact as the residential side. And the buyer's going to pay however much money that we all agree on for the earnest money. We have to list the title company and we need to list who is doing the closing. So who's the closer? All of that is normal. We've seen that before. Now, buyer will deposit an additional amount of whatever amount with the title company to be made part of the earnest money on or before this date. Just like the residential side, we see it a lot with people who are having to pull money out of 401ks. It takes more than 3 business days or 3 days in general for that money to leave that 401k account and come here to their pocket so that they can then transfer it or put it in a check form to that title company. So typically, like, let's just say the earnest money is going to be $5,000, but the person only has uh $2,000 cash right now, and they need to pull the other 3,000 from their 401k account. Okay, so then up here you would put that they have 2,000 now, and we're going to send it to this address in that state to this closer. But within this many days, let's say, give me another 12 days. Give me another 12 days, and then I can get you the other 3,000. Okay, so then now we've equaled my 5,000 in earnest. So just so that I did pay something within the 3 days that's effective, it is a good amount of money, and I do owe you more. Okay. Okay, now here it's talking about the buyer can instruct that title company to put the money into an interest bearing account, and then it will be credited to the buyer plus interest at closing. Now, why do we do that? Because typically, if we're talking commercial, I mean, we could be talking about millions of dollars. So if we kind of go on the unwritten rule for residential real estate, 1% of the sales price is what the earnest money is, right? So let's just say we're talking about $1 million. That's 100 grand and just earnest money. I want that money in an interest bearing account so that while we're in this process, there's interest being built on this money because it's cash and it's going to sit in an interest bearing account. And there you go. Now, the title policy and survey, very similar to what you see in the residential side. Who's paying for the title policy? Do we want the shortages read? Who's going to pay for that? And as we've seen in the residential side, and then within this many date, there will be a title commitment. Now, this could take in a residential contract. We see that it's 20 days, and there's no discussion about it because that's a commitment for the title company to make it to 20 days. With commercial, though, some commercial deals take years. So we are discussing and negotiating how long do we all think that this title company can get this done, and then we are putting that in the contract. Okay. With your survey, it's the exact same as one portion of it is the exact same as what we see on the residential side. Either there's already one, the buyer's going to pay for one, or the seller's going to pay for one. And if it's not accepted, who's going to pay for it at that time? Okay. The difference is if the buyer is going to obtain the survey at the buyer's expense, the buyer then has to deliver that survey not only to the title company, but also to the seller. Look at that. Look at this verbiage. Buyer will obtain a survey of the property at buyer's expense and deliver a copy of the survey to the seller. The survey must be made in accordance with the ALTA NSPS Land Title Survey Standards, Texas Society of Professional Surveyors Standards, Category 1A, blah, 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 blah. But then at closing, check this out. The seller will reimburse the buyer this amount of money. Basically, what they're saying is a lot like what we do on the residential side. Again, I will pay for your staging. I will pay for your photography. I will not pay for that. You're going to pay for it up front, Mr. and Mr. Seller. And then at closing, I will refund you for, good faith, but if you end up closing with somebody else, I'm not fronting the money for your stuff. It's the same thing here. The seller is saying, I'm not fronting the money for this survey because I don't even want the survey. I'm selling it. But if you're going to buy it, you pay for it. I will reimburse you at closing. Okay. Seller at the seller's expense can go ahead and get it on their own if they don't want to go that route, or the seller will deliver a copy to the buyer and to the title company. And if it's acceptable, good. If it's not, then who's going to buy it? Okay. Now, the buyer's objections to the commitment and survey, however many days after receiving all of these documents, how are you going to object, which is the exact same thing as the residential side. Okay. Property condition, we're going to accept the property as in the current condition and all of these things. Now, Feasibility period. We call it an option period in the residential world. On the commercial side, we talk about the feasibility period. This feasibility period can be so long. I've seen commercial projects where the feasibility period is literally like 180 days. Like it's just some crazy amount of time. And you have to put, that many days and this amount of money for those days. And then, even then, after all the studies are done, environmental study, wildlife studies, engineering, you're doing easements and digging and potholes and all of these things like burrs and burr holes and trying to get the grade of the earth in the ground there. What level is this clay? All of this stuff can keep you from putting a shopping strip here. It could keep you from putting a housing development here or apartments here or whatever that might be. And even with that, you're agreeing up front, I want 180 days for this option period to opt out after spending all this money on all these other cultures and studies. But then just in case, I'm also going to pay an additional amount to get an additional X amount of days. Okay. If that's what I want to do right here in the feasibility period extension, I have to do this up front, because when I get to the feasibility extension later, just like in a regular deal, they might say no to that. Okay. So if you leave this with no dollar amount or whatever, then you're forfeiting your right to terminate under these circumstances here. Okay. All right. So the buyer will authorize the agent to release and deliver the seller the following at any time upon seller's request without further notice or consent to the buyer, and it's whatever the remaining portion of the additional earnest money which will be refunded to the buyer is. Now, Jasmine, what is this talking about? So when you scroll back up here, the buyer can pay independent consideration of the buyer's right to terminate tendering such amount. Okay. So what we're saying here is you're putting so much money and time into this feasibility period. The buyer authorizes the escrow agent to give the seller some amount of money after the time, with no further request, because I'm already paying so much money to do all these reports and everything. The land has to come off the market. So go ahead and give the seller this amount of money with no discussion from me. Right now, again, if no dollar amount is there, then your extension of the feasibility period will not be effective. Okay. Now, inspection, studies, and assessments. This is just listing what those are and that you are allowed to do them. Okay. And it also asks for property information. So we're talking about copies of current leases, notes, environmental studies, assessments, utility capacity letters, all of that stuff. Give that stuff over to the buyer. And then if there is a termination for some odd reason, you have to give it all back as the buyer. You cannot keep their documents, their private information about that land. You have to give it back. Okay. Contracts. So again, that's what this is saying. So buyer will not later than 10 days after the termination date return to seller all of those items described in paragraph 71, which are right here. Delete and destroy all electronic versions of all these documents and deliver to seller copies of all inspections and assessment reports related to the property that the buyer completed. And whatever you paid for, you got to give us that back too. You have to give us everything. Okay. Now this is obviously what you are agreeing to, because what if I say, well, I'll give you all your stuff, but I'm not giving you anything that I paid for. You don't have to, but I'm just telling you what this is all saying. Right. Okay. So now if there's any leases, we need to talk about the leases. You need to give me all the information about the leases. You have to do all of that kind of stuff. Give me the information I need about these leases. Okay. Same thing about the estoppel certificates. Now, paragraph 9 is actually all the real estate information, the broker fees, who's paying what, how much, all of that good stuff. That's what's happening here. Instead of it being at the very bottom of the contract, they have it here in the middle of the contract. And you also have the closing date. That's right here in the middle of the contract as well. And it talks about at the closing, what kind of deed are we handing over, a general or a warranty deed, special warranty deed. Which one your client should take on is not your problem. You are not an attorney. Hire an attorney and they will tell you which one to take, or talk to the attorney at the title company's office. But you as a licensed agent, unless you are a licensed state attorney here in Texas, we are not giving advice based on what type of deed or title somebody should take on property. Okay. At closing at seller's expense, will also deliver to the buyer all of these things. And then the buyer at their expense will deliver all of these things. Same information that we see in our regular contracts. You know, you're going to provide that all title, HOA, everything has been paid up to this point. You're also, as a buyer, you're going to say that the money that I'm giving you is good money, it's good funds, things like that. I'm going to pay my piece. I'm going to do my part. We're going to talk about possession here, special provisions, sales expenses, buyer expenses, seller expenses. What are the prorations? What rollback taxes do we have? Rent and security deposits. What is defaults? All of these things is what we're talking about here at this point. So when we're talking about rent and security deposits, rollback taxes, and everything, again, this is just going to give you the definitions of all of that, what happens, time periods, what paragraph to refer to, default, and it gives you the option here to enforce specific performance or seek such other relief or may be provided by law. Again, why are we talking about all this? Because we're talking about commercial property. It could simply be a deal. We're talking millions of dollars. I'm probably going to sue for specific performance when we're talking about millions. Okay. If without fault the seller is unable within the time allowed to deliver the certificate, surveyor or the commitment, buyer may do all of these things, except as provided the seller fails to comply with this contract, the seller can do these things. Again, they're being very specific on what default means, what condemnation means, attorney fees, escrow, who pays that, what are the processes through the escrow person and all that good stuff. The seller or buyer intends to complete a 1031 revenue IRS document or exchange or anything like that if needed. We're saying that we're going to do that. And then material facts, you know, except otherwise provided or any material defects, you know, sign the commercial seller's disclosure notice. Basically, what is going on with these documents here? You have your notices, and that everybody has received all of these notices. You're putting that here. Dispute resolution, agreement of the parties. What does all this mean? Other addenda that are attached to this document. Again, we see a lot of this with our residential side. And then the buyer may or may not assign this contract. We are disclosing this right here. The time, effective date. What does all this mean? Additional notices that are given. Just information. This is all additional notices that are given. If we're talking about PIDs, PUDs, things like that, the contract as offer in the time zone, you have to have it unless the other party accepts the offer by 5 p.m. in the time zone in which the property is located on blank in this spot, you know, on this date, the offer will lapse and become null and void. Okay, so it's giving them a time limit. And now we have our signature page. We have agreement between brokers, which you do not fill any of this information out because you put your terms as far as your commission and everything on page 9. And that is it. A lot. This document is packed full with information, and there's still addenda, plural, right? There's still addenda that you attach to this that gets even deeper because, again, we're talking about commercial property. We could be talking about millions of dollars. Now, also understand that there are some people who will buy commercial property and they will not use our TR documents for it. Okay. They will have an attorney draft the intent letter of purchase and they will go with that. TREC does not promulgate any forms for us to use on the commercial side. So TR tries to help out and they give us a ton of documents that we can use in reference. But for the most part, the really big commercial brokerages out there, they have an in-house attorney that drafts all that stuff for them. Okay. And they draft it according to what the needs are of that client. Okay. Now, when you're searching for these properties, when you go to your MLS, you're just going to your regular MLS. And what you're looking for is land on the search and you're hitting detailed. Now, in our residential land video, we talked about everything that you see here, road frontage, number of lots, lot description. We talked about all this stuff where you do it again. But the difference is when you do this, first of all, we want to get rid of all of this because that means that it's under contract. We want unimproved land, but right here, we want specifically commercial land. Okay, that's how you eliminate. So we went over 5,000 items down to 272 items that are listed in this MLS, period. You are specifically looking for commercial land. You have to tell the system that you want that. Okay. There's no button to choose from. You have to specifically say that you want commercial land, period. All right. So now you're putting your city, your zip code, with the distances, what prices you want, the land size, how many acres, the dimensions, road frontage. Again, your road frontage is literally how much road is in front of your property. So if you only have 100 feet of road frontage, there are houses that are being built on 75 feet of road frontage. So 100 feet of road frontage is not that's not a lot for a commercial building. You might need something more like 5 to 800 feet of road frontage, because you need multiple water lines if you're doing apartment complexes, if you need multiple fiber optic lines and sewer lines. You might need all that kind of stuff because Walmart has more than one bathroom and more than one stall. So you might need more road frontage. Number of lots, is it a mud district? Will it subdivide or not? And how big of acreage do you want in a range, right? So once you do all of that, it gives you these results. You hit results here, and it gives you your full list, gives you your full list. So here's 11 acres for 9,000 an acre. So here you go. Okay. So it's 496,000 square feet. It's unimproved land. Let's see where this one is. Okay. So this is in the middle of Van Horn, Texas. Okay. It doesn't look like there's any roads to get here or anything. So, good luck. But just to give you some ideas here, right? And it gives you all of your possibilities. It gives you all of the pictures. It gives you as much information as it can give you, and you just keep pushing that way. Okay. Outside of this, if you wanted to send it in an email, what you would do here is you'd go back to the agent single line, click all of them if this is what you want, and you can either do save and create an auto email for somebody, or I'm sorry, a new safe search for someone, or you can either go back to actions and then you can do just a standard email and email everything that you just saw to somebody. Either way. Okay. Perfect. All right. So if you're looking at unimproved property means that it's just land. There's nothing else on it. Unimproved means it's not improved. It's just land. So if that's what you're looking for, then you're either using it on the commercial document that we just went over, or go watch the video about unimproved property on the residential document that is promulgated by TREC. All right. If you need anything else, if you have any other questions, give me a holler. Call, text, email me. It doesn't matter. I'm always here for you. Have a great one. Thank you for joining me.